as facilitator.
How many of you have handled an appeal before, or participated in working on an appeal in your office? Okay. How many of you have done that in the context of a criminal case? Okay. What I want to do is give you kind of a step-by-step suggestions of what you need to do to get the case up to the appellate level. And these are not, I'm not nearly as smart as these guys, but I thought that kind of a practical step-by-step approach might be of some assistance. So if this is just too basic, forgive me. If I know public defenders at times I've been in the position where you try a case and lose, and you're also the appellate lawyer. That's a little bit easier because you know the posture of the case, because you're counsel for the defendant. But the flip side of that is probably the position that a lot of you will be in by participating with us, is somebody else tried the case, and somebody else lost the case. You're in the position of being handed a file for an appeal that you had nothing to do with. You didn't have any participation in framing any of the issues at trial. You've got to pick it up cold, search for issues, and get it up on appeal. Okay? That can be a little intimidating. So the first step is this. Determine the status of the case. In my opinion, nobody cares what I think, especially my wife, but in my opinion, if you try the case and lose, if you're the trial counsel, I think the skeletal motion for new trial that Chris was talking about should be filed by trial counsel or it's malpractice. Now, that's my opinion. And what is important for you as appellate counsel is determine, first off, what is the posture of the case? Has the case been tried and lost? Presumably the defendant's they've had a verdict and sentence imposed, so that is the full judgment in a criminal case. At that point, the judgment's been entered. What you've got to decide as appellate counsel is more than likely you're not going to get an appellate file 2 weeks after the case is over. Usually you get it months later. And by that point, you need to determine, has the motion for a new trial been filed properly within 30 days? Or has somebody filed a notice of appeal, which changes the timelines considerably? Or has the trial lawyer for the defendant blown a deadline? That's important. I've had, Jim Bonner probably won't remember this, but several years back, I represented a guy in an armed robbery that had been tried by another lawyer. It had been tried twice. It was very convoluted. The guy was convicted and got 1 million years, and I was the appellate counsel. And I went ahead and did an amendment to the motion for the trial and had a hearing, and it was denied. And then when it was time to go up to the Court of Appeals, the clerk from Bullitt County calls and says, "Where's the motion for new trial?" Now, in Bullitt County, there are one of two chances. Either one wasn't filed, or it was and she lost it. Well, nobody could ever file. You think I'm kidding? There are probably pleadings at her house. I'm not really exaggerating. But at that point, I realized that the guy's paid lawyer had tried the case, had lost the case, and said, "All right, I'm done." Had not even filed a skeletal motion for new trial to protect the defendant's direct appeal rights. So your first job is to determine what is the posture of the case. If a deadline's been blown, as these guys talked about, then you consider a motion for out-of-time appeal, which is asking the trial court to give us the opportunity to go up on direct appeal. Most of my judges are lenient about that, but I have one judge in my circuit who's a pretty hardcore right-winger, and sometimes he'll deny the requests. And you know, that's pretty unfair to a defendant who's in jail or in prison. He can't do anything about what gets filed in the courthouse. So determine that. In the usual case, the judgment's been entered and the trial counsel has filed a skeletal motion for new trial. so that appellate timeline is protected. The beauty of the motion for new trial is you've covered your 30 days, and the trial court usually barely knows they're even filed. And you're not on anybody's radar at that point. It buys you time, as the question was, it buys you the time to request the transcript, and do some of these other things I'm going to suggest. And then you're kind of in the position of directing when it comes up in the trial court for a hearing. In some cases, you can file a notice of appeal. The difference between a motion for new trial and a notice of appeal is you file a notice of appeal, as Chris indicated, jurisdiction gets involved, the trial court loses jurisdiction, and the timeline picks up enormously. It's easier to file a motion for new trial that gives you time to do the work that you need to do. Next thing I would do is, Cindy.
You mentioned what to do if a motion for new trial was not filed, and if the court were to grant the out-of-town appeal, what do you do then?
What we do is, there is a case, and I cannot remember the name, that says if the court grants a motion for out-of-town appeal, then the defendant is permitted to pursue any post-conviction remedies, including a new trial. That's right. I had a goofy burglary case in Screven County that's up at the Court of Appeals right now, where the lawyer who originally tried the case blew the motion for new trial. And the sad thing is there's a copy of it in his file, that was stamped file timely, but the clerk couldn't find hers. I know, it's scary. I mean, we're worried about the law. I just want to make sure the record's there. But at that point, I filed a motion for new trial. The court granted it, and then I gave the court an order that says, basically, you're permitted to file a motion for new trial. I filed a motion for new trial at that point, and the timeline started all over again. When that was denied, and I filed a notice of appeal, went up to the Court of Appeals.
So that's just so that's clear. If you get the permission to file an out-of-time appeal, that includes allowance for filing a motion for new trial right there.
That's a really good point.
That case is Ponder versus State, by the way.
That's right.
The one you're seeing.
That's Westlaw back there.
I would request the trial transcript. And one of the I think some of the mechanics that y'all will particularly have to concern yourself with, when we request trial transcripts in my office budget pays for the transcript. You probably are going to have to get some direction from the appellate division as to whether or not your law firm has to pay for that or the appellate division will. But that's just a practical idea. You want to get the transcript, and you want to order it pretty quickly, because there are some court reporters who take a long time to get you a transcript. There are some court reporters, we have ours, the Chief Judge's court reporter, who's going to retire in October. She gives you a trial transcript back in 30 days. She's just a master at it. And then we've got two others who take forever. So order a transcript as quickly as you can. If it's possible, I think it is helpful to get the trial lawyer's file. I mean, I can't imagine this happens very frequently, but perhaps the defendant gave the trial lawyer some evidence, like the names of 3 alibi witnesses the trial lawyer didn't bring to trial. I can't say that that happens all the time, but sometimes you'd be surprised, or you look down and look in the file and maybe you realize the trial lawyer wasn't all that prepared when he went to court. What I do is I try cases using 2 notebooks, a main trial notebook and a notebook dedicated to cross-examination of witnesses. And when I'm done, the contents of those trial notebooks go in the file, rubber banded together, so that if an appellate lawyer wants to say, I want to look at your trial file, I can say, here are my trial notebooks, so it's clear the work that I did. Then I would review the courthouse file. And I say that because it is important to review the courthouse file, to see what's in it, and also to see what did trial counsel file. Or are there orders in there that may have something to do with an issue to be raised? Perhaps there was a pretrial hearing where they ruled against the defendant. There's a written order in place. That'd be nice to know. But in the courthouse file too, for example, maybe you review the transcript and you say, wow, the judge gave a bad charge on identification. Well, it'll matter if you go back and look at the trial file and trial counsel didn't submit written charges. Then that issue might not be preserved for appellate review. Or, I had this happen too. I thought the trial court gave an improper identification charge based on the Brodus decision that came out a few years ago. I was all hyped. I finally found an issue. Then you look in the courthouse file and counsel did submit written charges and included an erroneous charge that the trial court gave. So that sure changes whether or not that's the trial court error or counsel blew it. But those are the kind of things you can find out in the courthouse file. You know, God forbid sometimes you find letters that your client wrote to the judge. Things like that are out there too. I had a case on appeal that the guy fired, our office represented him, the guy fired us, he tried his own case and lost. And then he writes and says, I want an appellate lawyer. And I picked up the case only to find out that he had filed all kinds of pro se stuff there. It was already at the Court of Appeals. And, you know, now you know why my hair is white. So I had to ask for an extension from the Court of Appeals to submit the appellate brief, and I got a whopping 5-day extension. But I won the case. Not necessarily in order, file an entry of appearance. And that's really important, particularly in the position that you guys are going to be entering this business in, since you're not really connected to the trial lawyer necessarily. And in some instances, you might be entering an appearance in a case that's not even in your county. An entry of appearance is important because when a trial judge subjectively decides that this case has been sitting around here long enough and wants to set it down for a hearing, there's an entry of appearance in there. They know to send it to you. What you don't want is just take the file and not file your entry of appearance, because if they set that thing down for a hearing, you might not get notice of it. Once you get your transcript, basically what you're doing is issue spotting. And what I do sometimes is I'll go through a whole transcript and keep a separate list of possible issues to raise an appeal. Now, it may come down that I make a list of 10 things and go back later and say, well, 5 of them aren't really meritorious, but these other 5, you kind of narrow. But the first thing I think you do is issue spot. And one of the things that you need to be particularly concerned about is you can spot the issues, but were they preserved properly for appellate review? If they were, great, you can take it up on direct appeal. If they were blown, you might have an argument that trial counsel was ineffective for not preserving the issue for appellate review. I think I did an outline on preserving issues, some issues for appellate review that I think is on the CD that's been submitted. And I hate to say this, the only reason I did that was I reviewed the transcript of a case that one of my assistants tried where he blew the motion to suppress. So I put together an outline and distributed it to the staff. So there's a list of this is how you preserve this stuff for appellate review. It's important. And there's nothing better as an appellate lawyer to read a transcript from a very good trial lawyer who very carefully preserves things